Well, good afternoon, everybody. Bill O'Leary. Happy Thursday. On this Thursday, as part of our Thirsty Thursday series coming to you live, I am an estate and elder law attorney. My firm is Legacy Planning Law Group, and I've been doing this series for about a year and a half now, where I go live every Thursday at about this time to talk about a different topic or issue that I deal with in my day-to-day practice. Wills, trusts and estates, elder law, probate, trust administration, and the like. So if you're thirsting for knowledge, as I like to say, and to start off all of these, if you're thirsting for knowledge, you've come to the right place. Today's topic is an interesting one. I get asked this question a lot. Should I put my car in my trust? Should I put my car in my trust? So, you picture that a trust basically is a box that you put together. You build a box, and an important step in that process is putting your assets into the trust, basically putting your stuff in the box. So the question is, okay, well, should I put my car in the trust? Well, in my view, the answer is no. 9 times out of 10, the answer is no. And the same would apply to a boat, no. Other lawyers may disagree, but I think the prevailing view among estate planning attorneys is no, you don't put a car or a boat into a trust. And there are a number of reasons for it. Number one, a trust, a revocable living trust, is used to make sure things pass smooth and easily to your loved ones after you pass away, that they're not finding themselves stuck in the probate court. And so again, that's why a living trust is used. Well, you don't need a trust in order for a vehicle to pass easily outside of probate. Why? Because DMV, Department of Motor Vehicles, already has sort of procedures in place to allow for the easy transfer of a vehicle. So here's what would be required. So, a family member dies. Somebody in the family would go down to DMV, and they would bring the original title, copy of the death certificate. If there's a will, bring a copy of the will, ideally a certified copy, and an affidavit that would say that the estate is solvent. DMV doesn't want to turn over title to somebody if the estate is upside down and owes money. If there is not a will, then DMV is going to require a second affidavit that basically would state that the estate is not in debt to anybody, and that importantly, the heirs have agreed among themselves on who the new owner is. So let's say that there are 3 kids, right? Well, they would have to agree and put it down in writing if just one of the 3 kids is going to be getting the car. So again, fairly straightforward. DMV actually has some forms already prepared that just need to be filled in order to accomplish this. So again, DMV has the procedures in place. You don't need a trust to do that. Another reason why we don't put a vehicle into a trust is that it brings unnecessary attention to the fact that you have a trust. So picture this, you have a trust and you in fact do put the vehicle into the trust. Okay, so now the new owner of the vehicle is the trust. And now you're driving around town and you get into an accident, and well, lo and behold, it's your fault. Here comes the lawsuit. Here comes the plaintiff's attorney. Will not take them long at all to figure out that a trust owns the car. Won't take much digging at all. Well, what do most people think when they hear the word trust? Well, they think money. So this person must be rich. And so it tends to sort of distort, if you will, that legal case and inflate the settlement value of the case. So it brings unnecessary attention to the fact that you have a trust, which otherwise is a private affair. So again, there's no upside to putting a car in a trust, because you don't need a trust for the car to pass outside of probate. There's no upside, you don't need it. And there's nothing but downside. You bring unnecessary attention to the fact that you have a trust, okay? There's some other reasons why we don't put a car into a trust. DMV might very well assess a sales tax for that transfer, the transfer from you to your trust. Now, if DMV knew what they were doing and were following their own rules, they would not assess a sales tax. because what you would do on the transfer form is check off the box that says this is a gift, it's not a sale. There should be no sales tax on a gift. There should only be sales tax on a sale, right? But the problem is DMV don't always get the brightest person that you're dealing with, and they might assess a tax anyway, and now you're having to challenge that tax assessment. So don't even go down that road, okay? So again, another reason why we don't put a car to trust, the possibility of having to pay sales tax or at least fight the issue. Another reason has to do with the insurance company. The insurance company might increase premiums if the car is now owned in the trust. They, in fact, also might even deny coverage. If you get into an accident and you file a claim, they might deny coverage. And then one other reason, and this is for people that have a car with a loan on it, and that's a lot of people, okay? Well, what would happen if you transfer a car into a trust that has a loan on it? You have to either pay off the loan before you transfer the car to the trust, or get the consent of the lender before DMV is going to allow the transfer. Well, the lender may consent to it, may not. Who knows? So there are some obstacles to transferring a vehicle into a trust, and really there's no real benefit to it as well. And the same sort of analysis would apply to a boat. Because the same DMV forms are used whether it's a car or a boat. Now, having said that, there are some occasional exceptions. Let's say it's a fancy sports car, maybe a classic car, antique car, or a really expensive boat. Then we probably go ahead and transfer it into a trust. Might even utilize an LLC if we're talking about a boat. But short of those situations, sort of the typical run-of-the-mill, we don't put a car into a trust. One other thing, this is sort of a bonus coverage. So we recommend that the car stay outside of the trust. It will remain in the ownership of the client, that the client own it. But what we also will tell clients is you don't want to own the car together. Let's say it's a husband and wife. You don't want to own it jointly. Why? Very simple reason. If we step back, and we're not talking about a vehicle, but we're talking about all of the other assets that you may own together as a married couple. If you own them together jointly as husband and wife, they're given tremendous protection under the law. It's what we call tenancy by the entirety. So in the eyes of the law, that asset, whether it's a piece of real estate or a financial account, it's not owned by two people, but sort of an indivisible unit of one. If one of the spouses incurs some legal liability, think the car accident, it's their fault, here comes the lawsuit, that injured party cannot get at that jointly held marital asset. It's protected. Okay? The one big exception to that general rule has to do with vehicles. So if a married couple owns a vehicle together, jointly, and then one of them gets into that car accident, here comes the lawsuit. Now all of your jointly held assets are at risk. So we always tell people, first, you don't need to put sort of the run-of-the-mill transportation vehicle into the trust. Secondly, we will ask, okay, now how do you own it? Because we want to try to help them protect their assets as much as possible. If they own it jointly, we tell them, when you leave our office, sort of half jokingly, but half seriously, you go straight to DMV and you get that car out of joint name. So what you'll do is figure out which spouse drives car number one primarily, put that car in that spouse's name. Who drives the second car primarily, put that car in that separate name. So, a little bonus coverage for you. So, hey, if you'd like to know a little bit more about whether you should put your car into a trust or not, and maybe how we can help, we would love to talk to you. So what we do is to sort of kick things off is to invite you to talk to us by phone, to have what's called a discovery phone call. It's a free 15-minute phone call where we get a sense as to what your situation is, what your concerns are, why you're reaching out, and also whether we might be a good fit. So again, that call is complimentary. You can just call us here at the office, Legacy Planning Law Group, Google us, or you can actually book it either on our website, or you can book it on the Facebook page. Just go to the Book Now button. So hey, if you've enjoyed this video, I would kindly ask you to like it, and better yet, if you would share it. I really, I think a lot of people. This is probably one of the most common questions that I get. Should I put my car in my trust? I think a lot of people could benefit from that. So it'd be great if you could share this. So again, I hope you've enjoyed this talk on whether you should put your car into your trust or not. I plan on giving another talk next Thursday about this time. Just a little different topic, something that sort of catches my interest that week. So if you're thirsty for knowledge, we will quench your thirst. So Bill O'Leary, signing off for now for this week, and I guess when we see you next week, yes, we will be in the month of September. Can you believe that? The month of September. We are already 2/3 of the way through the year 2021. So signing off now. Go make it a great day and a better world.